You have challenged the petitioner before your lordship. Please, officer on special duty of the His Excellency, my lord. See, unconstitutional and out malicious FIR has been started. Petitioner and other staffs of the Raj Bhavan, my lord. Now, my lord, we have challenged the entire FIR. My lord, this is the certified copy of the FIR. I shall not read in open court. If your lordship, then I shall make my argument before your lordship. First,
Yes.
your lordship, see.
No, you start.
If your lordship see the FIR, kindly can't.
Petitioner is one of the
But he is the officer on special duty of
OSD.
His Excellency.
All right.
From 35 copy just now which I have handed over, your lordship will get the FIR there. The written complaint.
Yes, yes, it's there.
Handed over. Milord, kindly turn to page 9 of the Milord, the certified copy. Milord, the FIR part. It is
Yes.
very, very important. If your lordship kindly see it. Milord, kindly see the date of lodging of the complaint, 15/5/2024. Milord, got it? Top
Page
of the,
9, you say?
Milord, the internal page 9. The first
There
part,
are two paginations.
the formal
Wait,
part.
wait.
Formal part.
Yes.
Yes. Milord, kindly mark the date 15/5/2024.
Yes.
Then, Milord, kindly see the sections 341
Hmm.
and 166. Milord, 341 speaks about wrongful restraint, punishment for wrongful restraint. The punishment either for, Milord, 1 month or for 50 rupees, 500 rupees. This is the maximum punishment in 341. Although this is a cognizable offense, that is the reason they have started the FIR. And 166, Milord, it is, Milord, the abatement. Milord, it doesn't have any specific definition. Abatement is connected to the original offense. But I shall show your lordships, Milord, none of the offense here in the FIR which is applicable so far the present allegation is concerned. This is number one. And second, I will show your lordship, Milord, if your lordships take the face value of the FIR, it will not constitute any offense against the present petitioner. And there is a constitutional bar under section 361, article 361, which says, Milord, there cannot be FIR can be registered against the His Excellency. Milord,
No, but then this FIR is against. You say the petitioner is has also been
Milord,
named in
read
the
the
FIR.
contents, Milord, then your lordship will understand the entire thing, Milord. First, Milord, I shall show it the timeline also. Milord has gone through 341, 166 first.
Yes, 1 minute. Yes.
Yes.
The timeline is there, and
Now, Milord, it is
serial
very
number
important. I
7
shall come by one, Milord. Kindly see
details
the occurrence of the offense. Milord, it is very important.
the
Thursday.
occurrence of the
Milord,
offense.
kindly
first.
marked it. Thursday,
Hmm.
2/5/2024. That means
Yes.
after almost 13 days, they are lodging this complaint. And who is the complainant here? Milord, kindly mark this name. Sabonti Ghosh, Inspector, Hare Street Police Station. Milord, got it, Milord? Kindly
Yes.
marked it also. Now, Milord, kindly turn to the written complaint. Next page, Milord. Till now, our name is not there, Milord. Now, kindly, but the FIR itself says 361 regarding the prosecution against the Milord, His Excellency. That they have stated. Now, Milord, kindly, there are three parts of the FIR which your lordships has perhaps noticed. First part, 19th, asks for the CV. Second part, on 21st, where the actual incident took place, inside the chamber, as per the allegation, Milord. Third part, Milord, your lordship will find on 7/5, Milord, this is the 22nd, Milord, the 2nd of May, she comes out from the, Milord, the place, Raj Bhavan, and lodges the complaint with the police station. She doesn't disclose anything against, so far as the petitioners are concerned. On 7th again, Milord, this is the afterthought I am saying, and the officer who is investigating the matter, it is her brainchild. She says, on 7th, Milord, again she came and, Milord, the allegation is this, Milord, that we have...
Did you not implead that?
No, it's a
victim?
suo moto case by the, Milord, the police officer, so we could not implicate her. It's a suo moto case. Milord, kindly see the fourth paragraph, Milord, the allegation so far as the present petitioner is concerned. Kindly see, Milord. On 7/5/2024, the lady further revealed on 2/5. There is a complaint on 2/5/24. That is the previous paragraph. Your lordship will find the lady came to the Hare Street Police Station. Her complaint was received. One person named Supriyo Mollik also joined her for the given mental support. That is ended on 2nd of April. Now on 7th, our name is not mentioned in that complaint. Now 7th of May 2024, the lady further revealed 2/5/2024 when she left the room, so and so, she reached to room and a state of emotional distress. Some Raj Bhavan personnel included the present petitioner, OSD on so and so and so and so, asks her not to disclose any fact, but kindly marked it here, pause it here a moment. Admittedly, this lady, she was alone inside the chamber of of His Excellency. There one person was there. The officer said, "No, you need not be present here." She was alone. Now, this part they are saying, which they are saying that she reached the investment stated condition with included so and so, locked her and asked her not to disclose any fact. Your lordship knows there is a principle in Bhajan Lal, the principle number 5. It says, if the allegation, if your lordship takes their face value, will not constitute their offense. This is number 1. And second, where the allegations in the FIR is so absurd and inherently improbable. Admittedly, the lady was alone, and the allegation is that we asked her that not to disclose anything. So as if that we know what has happened there, which is absolutely improbable. That is the reason, in Bhajan Lal, principle number 5, your lordship is more than aware of me. This principle was introduced, saying that the allegations are absolutely absurd. We are falling in this category. Something happened there. Admittedly, she was alone. Now she is saying we obstructed her and disclosed her not to say anything to her. And the main ingredients of 341, which is the offense which is a cognizable in nature, it says, wrongful restraint. Now, there cannot be a partial, restraint. 341, your lordship will see the paragraph, your lordship will find the last line it shows, but somehow she managed to leave the room. Kindly marked it, the same para. This will not attract so far the allegation under section 341 is concerned. The restraint has to be a complete restraint. If it is a partial restraint, this will not constitute the offense. I am relied by a judgment of the Honorable Bombay High Court, in pre-independence, if you will see the language. Just one para, what is the ingredients of 341? This case, the accused was convicted wrongful restraint, same as us. Here, the accused was already convicted. Under section 339, that is the definition of wrongful restraint. And so and so. An appeal to the district magistrate, so and so conviction was appealed. The learned district magistrate, however, find a fact that the person said to him obstructed was still able to proceed according to the passage in question. Same in our situation. That being so, we do not think that he can said to have been wrongfully restrained. Seeing the definition of 339 requires the obstruction should be so complete and successful as to prevent the person obstructed from proceeding in any direction in which he has a right to proceed. So if they says, in the FIR, your lordship has gone through it, she managed to escape. If that is so, the definition of wrongful restraint will not attract, and from the face of it, the section has no manner of application so far as the present petitioner, the case is concerned. And so far as 106(16) is concerned, I told you, your lordship, it's an abatement and it is a non-cognizable offense. FIR on the first instance cannot be registered. So on these two scores, the FIR should be stayed. And see the conduct of the police also. Just the malafide part I shall address your lordship. Kindly see what the police has done. In my residence on Sunday, this WhatsApp was given by the Hare Street police station. Will get it in 1:40 p.m. and asked me to appear on the same day between 3 to 5. This notice was given 1:40 p.m. 2 to 5. I'm sorry, 2 to 5.
Page 40 is dated 18th of May.
Yes.
And to appear on the 19th of May.
But it was sent to me via WhatsApp. Your lordship will get that in page 39.
39 is quite illegible. At least my eyes cannot be strained to such extent to read it. Whatever, I take it that it's on 19th that you received it.
Yeah. Now, I write a letter to them in page 41 that what is the allegation against me? Please let me know. Because I have a right to know the allegation. As because you have not uploaded, as per the Youth Bar Association judgment, it has to be uploaded within 24 hours. Your lordship knows in your website. Nothing was uploaded. 15 to 17, you appear before us. Now, on the same day, because after getting the notice, being a law-abiding citizen, I returned from Delhi. My boarding pass is page 43. Now, after coming to know the case has been registered against me, immediately, kindly see my bona fide. I surrender before the landed jurisdictional magistrate and obtain bail. Since these are, the 341 is a non-bailable offense. 7, your lordship will find that on the pretext of this investigation, which is biased, baseless, the unconstitutional, and out and out malicious, all the employees of the Raj Bhavan, they have been called by the, my lord, the police authorities. Your lordship will find from 47 onwards. Notices after notices have been given to the officers of the His Excellency, my lord, to go and, my lord, they join the investigation so far as this allegation is concerned. Now, my lord, your lordship knows better than me. My lord, the principle of quashing in Bhajan Lal's case, there are 7 principles were there, my lord. Now, recently in Supreme Court, now, Haji Iqbal, my lord, one addition was given by the Supreme Court, additional prayer. What should be the role of the court so far as the role, my lord, the quashment of the case of this concern? My lord, kindly see this judgment once. Only one para I shall rely on. Para 14. It's a very recent judgment, my lord, 2023, SCC Online 948, Haji Iqbal. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent power under section 482 of the Code of Criminal Procedure or extraordinary jurisdiction, blood in our petition lies here, under Article 226 of the Constitution, to get the FIR or criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with ulterior motive for wreaking vengeance. This is such circumstances the courts owes a duty to look into the affair with a care and more little closely. My lord, kindly pause it for a moment. Then, my lord, the next sentence. We say so because once the complainant decide to proceed against the accused with an ulterior motive for wreaking personal vengeance, then he would ensure that the FIR complaint is very well drafted with all necessary pleadings. The complainant would ensure that the averments made in the FIR or complaint are such that they disclose the ingredients of the constitute the alleged offense. Therefore, my lord, is very important, my lord, this sentence. Therefore, it would not be just enough for the court to look into the averments made in the FIR and complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes you the duty to look into many other attending circumstances emerging from the record of the case over about the averments, and if be needed, with due care or circumspection, try to read between the lines. Not exactly, my lord, I asked your lordship to read between the lines. Your lordship has seen the allegations. The entire incident happened inside the, my lord, the chamber of the His Excellency, but, my lord, as per the complainant, so far the role of the present petitioner is concerned, as if they know what is happening there, which is so absurd, which is squarely applicable so far as this judgment is concerned, as well as the Bhajan Lal's principle number 5. The court, while exercising its jurisdiction under section 482 CRPC or article 226 of the jurisdiction under section 482, is not restricted itself only at the state to a case, but empowered to take into the account the overall circumstances leading to initiation of registration of the proceeding. My lord, kindly pause here, wait a moment. Here, my lord, the overall circumstances. The police authority knows they cannot proceed with the actual person because there is a constitutional bar under section 361. So what to do? We have to do it in another way. So register a FIR, which is afterthought, which has no manner of application, the sections which are put here, and harass the persons who are associated with the His Excellency's office. This is the whole intention of the prosecuting agency. But the face of it, my lord, this FIR is illegal.
Let us, my lord, dissociate two offences in this case. First offence is which we cannot, my lord, investigate. That is an allegation of molestation. The second is what had happened thereafter. Now, thereafter, what had happened is, my lord, when this lady, my lord, after being whatever done by His Excellency, when she came back to her office, which is called the peace room in Raj Bhavan, then, my lord, the employees over there, my lord, tried to prevent her to go and lodge any complaint. That is why, my lord, this case has been started, my lord, under section 341 of the Indian Penal Code, which is wrongful restraint. Now, my lord, my learned friend has made a lot of submissions on whether at all 341 applies or not. In my very respectful submission, these are matters, my lord, which are to be gone into, my lord, at a later stage. Because when somebody complains to the police, at that stage, my lord, it is not the duty of the police to look into whether there is a partial restraint or complete restraint, full restraint or not. Therefore, my lord, if the complaint discloses a cognizable offense, my lord, I have a duty to register a case for investigation. Now, my lord, so far as, my lord, investigation is concerned, my lord, your lordships have held that investigation is not made against any particular person. FIRs may be against named persons, may be against unknown persons. Investigation is always made into the offense, and thereafter, even Milord, your lordships have also held that the person who is the complainant becomes the accused after an investigation, or persons who have been named as accused, their charge sheets are not filed against them. There are various Milord, consequences, if I may say so with respect. Therefore, Milord, we need to first dissociate whether the case over here or the present complaint, Milord, involves whether, Milord, the Raj Bhavan staff had prevented this lady to go forward with her allegations and to take recourse to law. Now, what is being submitted before this court is that since we cannot do anything against His Excellency, therefore, Milord, His Excellency's employees are being targeted. Now, Milord, on this, Milord, kindly look into, Milord, two paragraphs of the writ petition. I am very surprised that why in paragraph 9 and para 17 so much have been said qua article 361 of the Constitution. Milord, the flavors of the immunity granted to, Milord, the governor is sought to be assumed, and the protection is sought to be taken from that, which they cannot. But I'll come back to, Milord, what had happened in the investigation, if at all that is required. Milord, please have a look to, Milord, a judgment, a very old judgment, Milord, of the Honorable Hyderabad High Court of 1955. Mr. Bandyopadhyay has a copy. Milord, he'll hand up a copy to your lordship, Milord.
I did not. I coming dear each. AIR 55 Hyderabad 241. 251.
So it's a very lengthy judgment. Please take, Milord, paragraph 121, 120 in the Raj Bhavan, which on the face of it may not necessarily involve the Raj Pramukh personally and may involve his servants or officers or other persons resident therein. So this is the reason, Milord, why I said, Milord, that we must dissociate the two offences. Now please take, Milord, 122. We are not very much impressed by the argument of the learned advocate for the revision petitioner that even in a case where the Raj Pramukh is involved, along with any other person or persons actually committing the offence, no action can be taken against those persons because the prosecution of such a person or persons would also involve the Raj Pramukh, such as in the case of an abatement of the offence by him. When an immunity has been conferred on any person, it must be so construed as to limit it to the person on whom it is conferred and cannot be extended to others who under the law may be liable. When we are in a case of joint interfering with the immunity that the governor has. Milord, this was not the only incident which the lady had reported or faced rather. Milord, this had happened at least twice as per her complaint against the governor.
That is against His Excellency.
Yes,
This
Therefore,
person,
yes,
petitioner.
therefore, Milord, in our state, at least now you will find that people are coming out today, Milord, against these persons. Now, please consider the situation of this lady who could somehow gather courage, because that was the incident between the governor and this lady is not a solitary incident, which your lordship may look into the complaint of the lady, Milord, so far as the governor is concerned. Therefore, Milord, once, Milord, she gathers this courage and comes before the police or before the court, Milord, there may or may not be some inconsistency in that. Milord, these, Milord, lines, my learned friend is right. The Supreme Court has said that it should be read with care and circumspection, and also, Milord, taking the overall circumstances. That is
Yes.
very important.
Right.
Milord, please, Milord, whoever is to consider has to consider in the armchair of that lady. It is unexpected that, Milord, the FIR would be like a petition. Now, Milord, some inconsistency here and there, Milord, I don't say that inconsistency is there, but even then, assuming for argument's sake, Milord, your lordships have held that FIR is not an encyclopedia of facts. It is only to report an offence. Now the police is to investigate and find out what is the number. So far as I am concerned, or for that matter, my lord, so far as the court is also concerned, my lord. But at this very stage, my lord, please consider, my lord, whether, my lord, the FIR is to be scrutinized with precision or not. But the only thing,
Let the regular bench do this work.
yes, but kindly, my lord, this is not a case that, my lord, somebody will be put behind the bars.
Yes.
But these are, my lord,
Included in the complaint with the allegation that she was restrained from lodging the complaint. Stop. Next. 41A notice was issued to the petitioner, which he complied. Stop. The petitioner has also obtained bail. Have you annexed the order?
Yes, yes, my lord, from CMM Calcutta.
Page
Page
45.
Page 45.
45.
On what is the day? 21st of May 2024. Stop. Paragraph. The petitioner alleges that the FIR was not uploaded and he had to obtain a certified copy to know the exact allegation lodged against him, allegation made against him. Stop. Paragraph. The allegations have been read out by the learned advocate representing the petitioner. Stop. Paragraph. It has been submitted that the allegations are quite improbable and no case would have not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to the intention/registration of the case, as well as the materials collected in the course of investigation. Stop. Reliance has also been placed, paragraph, on the judgment delivered by the High Court of Bombay, reported in 1912, SCC online, Bomb 5, in the matter of Emperor versus Rama Lala. Please check the spellings. Wherein the court was of the opinion that in case of an obstruction, the same should be complete and successful as to prevent the person obstructed from proceeding in any direction in which he has a right to proceed. Stop. The wrong defined is a wrong against the person and is not completed where the person is at liberty to go in any direction he pleases. Stop. It has been submitted that the complainant has mentioned in the complaint that she somehow managed to leave the room. Stop. It has been contended that as the complainant was able to leave the room, accordingly, it cannot be taken that the allegation of wrongful restraint is a proper one. Stop. Prayer has been made to quash the proceeding and the FIR that has been lodged. Stop. Paragraph. Learned government leader, learned advocate general, opposes the prayer of the petitioner. Stop. It has been submitted that there is no tearing hurry in passing any order to restrain the investigating officer from proceeding with the investigation. Stop. The complaint that has been lodged is not absolutely improbable. Stop. It has further been submitted that the petitioner, that there was no intention to arrest the petitioner at the very first stage, and that is the reason notice under section 41A CRPC was issued. Stop. The petitioner has already obtained bail, and accordingly, the investigation at this stage ought not to be stalled. Paragraph. it has been contended that the improbable theory that has been relied upon by the petitioner has to be looked into with circumspection and the attending circumstances. Stop. Paragraph. It has been submitted that the victim had lodged the complaint and lodged the complaint, and according to the various decisions laid down by the court, the FIR ought not to be an encyclopedia of facts. Stop. The complaint lodged according to the investigating officer, is not absolutely improbable. Paragraph. Prayer has been made to permit the investigating officer to continue with the investigation and revert with a report. Stop. Paragraph. I have heard the submissions made on behalf of both the parties. Stop. The matter is at an interim stage. Stop. Paragraph. The petitioner has already obtained bail from the competent court. Stop. The evidences, that is the CCTV footages, are already in the custody of the investigating officer. Stop. Next. The complaint, the offense against the offense for which the petitioner is being tried is of wrongful restraint and abatement. Stop. The complainant in her complaint has mentioned that she was made to sit inside the EPABX room, and the petitioner blocked her way and asked her not to disclose any fact before any authority and not to make a hue and cry.